My lady, in our submission, the main question in this appeal is whether there is a category of information, namely information recorded in a record made when a person attends a hospital, which is treated differently from other categories of information when determining for the purposes of the tort of misuse of private information, whether there is a reasonable expectation of privacy in relation to the information. Standing back from the detail for a moment, that category of information is a subcategory of health-related information. Yet we know from ZXC and Bloomberg, in passages I'll take you to, that in relation to health-related information generally, there is no yes-no answer as to whether there is a reasonable expectation of privacy. There is, in relation to certain categories of information, of which that is one, a legitimate starting point or a general rule that there's a legitimate expectation of privacy, but it is not an invariable rule or any kind of presumption. And even in relation to those categories of information, the court must consider all of the circumstances of the case, including, amongst others, the extent to which the information is already in the public domain. The core submission of my learned friend elevates the subcategory of health-related information, I repeat again, information recorded in a record made when a person attends a hospital, into a special category where the all of the circumstances of the case approach is not required. And in my submission, that is wrong in principle, and the judge's reasoning, faithfully applied, established authoritative case law in the field of misuse of private information, and then correctly applied the reasoning of the Supreme Court in Lloyd and Google. And I say in parentheses, it's noteworthy that no issue is raised about the judge's analysis of Lloyd and Google by the appellant. Correctly applied the reasoning of the Supreme Court in Lloyd and Google to the irreducible minimum scenario in paragraph 166 of her judgment, which, and this is an important point that hasn't yet emerged, she arrived at on the basis of essentially uncontested facts about the content of the record. Can I just show you that and explain a point which I submit is important when analysing the judgment generally, which it illustrates. If you go to paragraph 166 of the judgment, you'll see in her subparagraphs which build up to the irreducible minimum scenario, cross-references to the previous paragraphs where the facts are found. And it is important when reading this judgment to look back in any particular paragraph or subparagraph at what she has used as her basis. And if I could just illustrate the point I was making about the largely uncontested facts of the irreducible minimum scenario. Do you see that at 1663, she says the limited demographic information was recorded by the hospital receptionist so that only the person's name and a partial address was included in the HL7 message, with very generalized or no specific reference to the medical condition that had prompted the attendance. Referring back to paragraph 163, at 163 on the previous page, it's too long for me to read out, but all of it is important. She summarizes the evidence about the range of data that may be included or will have been included in the records transferred. And she makes the point in line 5 that the broad spectrum of variables has not been challenged by the representative claimant. And then she explains how that spectrum will mean that some people attended but left without seeing a clinician. And answering a question my lady the President asked this morning, He explains that in these circumstances, an HL7 message would be generated to record the person's arrival at the hospital. This would include some demographic information, but even the extent of this would vary. And then dropping down a little bit, in addition, an admission message would record the person had been admitted to the hospital, and it could, but did not always, include a free text comment from the receptionist as to the nature of their complaint. The message could be in very general terms, unwell, or simply record the individual was unwilling to divulge information to the receptionist. And my lady, just
asking, just as a matter of general context, as it were, in relation to somebody attending at the A&E, would the receptionist just take their name? I see what's said there, but the normal triage process would it suggest that some information would be taken apart from that, or am I wrong about that?
Well, the A&E isn't the only department of the
No,
hospital.
I know, but that's the example
Yes.
given there. It's just slightly curious that somebody would attend at A&E and only give their name and address.
It's also curious that the word receptionist is used, because, as with my lady the President, one would have anticipated a triage on arrival, and generally the person doing the triage would have some element of medical knowledge. I'm not suggesting for a moment a doctor or anything of that sort, but receptionists may minimise the qualifications of the person taking the triage.
Well, I see that in relation to A&D. I don't believe, and correct me if I'm wrong, I don't believe all the records relate to A&D. And in clinics and hospitals, it's quite common to see a receptionist.
No, I understand that, but that is the example which the judge gives. And Dr. Hughes says that individuals often attended the emergency department, registered their attendance, but then decided, perhaps after waiting some time, to leave without having been seen by a clinician.
Well, that was what
scenario.
That's what the evidence showed, yes. and the evidence was in a lot of detail from Dr. Hughes, whose background was as a practicing medical doctor and then a scientist with Google. And the judge makes the important point that this evidence about the range of content was unchallenged. And what she's looking for, of course, because it's put as a lowest common denominator claim, is the least or lowest common content. And she comes back to that, and could I emphasise the point she makes at paragraph 180, subparagraph 3 of the judgment. Where she says the content of the individual medical records that were transferred isn't known at this stage. However, the representative claimant hasn't disputed the defendant's evidence as to the lowest common content of such records, paragraphs 163(4) above. In turn, it's this content that's formed the basis of the conclusions I've reached at, amongst other places, 166, which is her irreducible minimum scenario. And lady, the findings of fact aren't challenged in this appeal, and they include what I've just shown you. I showed you it in part because it'll be part of the structure of my submissions to follow the judge's path back from conclusory paragraphs to paragraphs which contain the building blocks of her analysis. And our basic submission is both the reasoning and the outcome on the judgment below are correct. Ground 1A is perhaps the real meat of the appeal. It's that the court erred in rejecting the claimant's submission that all patient-related information generated in the course of the relationship between patient and healthcare provider, regardless of the content of the information in question, gives rise to a reasonable expectation of privacy, save in relation to direct care. Now, that is an attack on paragraph 133 of the judgment, which Mr. Pitpayne showed you this morning, but which I want to return to and seek to demonstrate that it is orthodox in its reasoning and conclusion. Mr. Pitpayne jumps straight to the judge's reasons in subparagraphs 1 to 6. But in my submission, it's very important to first focus on her conclusion before she gives her reasons. Her conclusion is, I do not accept that all patient-related information that's derived from the doctor-patient contest inevitably gives rise to a reasonable expectation of privacy outside the direct care situation. Where information of this nature is involved, I agree it will be a highly relevant factor to take into account in applying the approach I've identified in paragraph 67 above, which we'll go back to, but it doesn't follow that a reasonable expectation of privacy will always exist, irrespective of the circumstances and the content. And I emphasise the conclusion, and in particular her express recognition that the confidentiality of the patient-healthcare provider relationship is a highly relevant factor to take into account, to show that she wasn't unaware of the confidentiality of medical records. She expressly said that that confidentiality was a highly relevant factor, but not invariably determinative. And I said I'd take you back to 67 because she's reaching that conclusion in relation to the test which she has to apply. 67 sets out the now well-established test that whether a claimant has a reasonable expectation of privacy is an objective test. The expectation is that of a reasonable person of ordinary sensibilities placed in the same position as the claimant and faced with the same publicity. Bloomberg, she said it's in Bloomberg at 49. Lord Hamlin and Lord Stevens noted that the question is a broad one, which takes account of all of the circumstances of the case. Bloomberg at 50. They refer to a non-exhaustive list of factors in Murray, which are known as the Murray factors. And my lady, that all of the circumstances of the case test is well established and applies until this case, at least, in relation to all categories of information, even where the category in question has a legitimate starting point or general rule that there will be a reasonable expectation of privacy.
Would you distinguish between the information that's recorded and the fact that it's recorded on a medical record?
Well, misuse of private information has to focus on the particular information.
It goes back to a question my lord asked earlier, which is whether information in that context includes that it is information on a medical record. In other words, it's not just, for example, an address or a name, but it's a name on a medical record.
Well, my lady, it doesn't become information in respect of which there is a reasonable expectation of privacy simply by being recorded in a medical
I understand
record.
that's your case.
That's my case.
But the question is whether you would distinguish, and I think your answer is you would, between the information which is recorded on the record and the fact that it is recorded on a medical record.
Well, what I distinguish between, I hope doctrinally correctly, is the confidentiality that applies to the process and the relationship between healthcare provider or doctor and patient, and the process of providing information and it being recorded. That's a confidential relationship and process. But the tort of misuse of private information requires a focus on the specific information said to be private. And my submission is, and the judge was right to say, information doesn't necessarily become private simply because it's recorded in a medical record. Lady, I've emphasised the judge's conclusion at paragraph 133. Can I now draw attention to her reasons? Mr. Pitt-Payne took, sorry, I'm back in 133. Mr. Pitt-Payne took subparagraphs 1 and 2 together and suggested they were concerned only with a threshold of seriousness. Lady, that's not right. The judge, in fact, makes 3 points in 1 and 2, referring back to her analysis of paragraphs 67 to 69 above. The first is that it is very well established in the tort of misuse of private information that a threshold of seriousness applies. Go back to paragraph 69 for that and see that she takes that from Ambrosiadou and Coward, in the judgment of Lord Newburger, Master of the Rolls. Just because information relates to a person's family and private life, it will not automatically be protected by the courts. For instance, the information may be of slight significance, generally expressed or anodyne in nature. And she also cites Bloomberg at paragraph 55, where the same point is made. And I want to show you one or two passages from Bloomberg, so it might be helpful to have it open. It's in the authorities bundle at tab 23, which is page 792 in my hard copy bundle.
So which divider?
23, my lord.
Thank you very much.
I've shown you that she refers in 69 in the last line to Bloomberg at paragraph 55. That's on page 827 of the bundle, or 1193 of the report, where Lord Hamlin and Lord Stevens say the effect on the claimant must attain a sufficient level of seriousness for Article 8 to be engaged, citing Wood per Lord Justice Laws. In general, there will be no reasonable expectation of privacy in trivial or anodyne information. So that's the first point she collects at paragraph 133 from the authorities. At paragraph 68 of her judgment, she collects two more points from Bloomberg. The first is one I trailed at the outset, that there are certain types of information which will normally, but not invariably, be regarded as giving rise to a reasonable expectation of privacy, paragraph 52. One of the examples they gave was a state of a person's physical or mental health or condition. That's the point I made about health-related information as an overall category, not being one where there was an invariable answer. Depends even in that category on all of the circumstances of the case. But the second point she collects at 68 from Bloomberg is this. They also noted that a relevant circumstance was the extent to which the information was already in the public domain. Information that was private may become so well known that it's no longer private. Whether that's so is a matter of fact and degree. And then, my lady, she collects one more point at paragraph 69. Sorry, no, I've already referred to that. That's the threshold of seriousness. So the 4 points which she collects are all of the circumstances of the case test at 67, the certain types of information point at the first half of 68, and the public domain point in the second half of 68, and then the de minimis threshold, or the threshold of seriousness, at paragraph 69. All of those come directly from ZXC and Bloomberg, and in my submission the judge was not only right, but bound to follow them.
Can I just ask you on this proposition, because it's an interesting passage where they refer to Gatley and they just set out what Gatley is. But I mean, they're not writing a statute and rewriting this. They're just saying that normally people's medical issues are always likely to be private. But I mean, can you give any examples when a person's medical information wouldn't attract a reasonable expectation of privacy? I mean, it's all very well saying in all the circumstances, but what are those circumstances?
Well, the example, and the judge gives it in terms, is the person who's travelling to hospital with a fractured leg tweets publicly that she has fractured her ankle and is going to hospital, that would be medical evidence, evidence about medical condition and intended or imminent treatment, which the patient had deliberately chosen to make public, and which would not attract a reasonable expectation of privacy. That is one of the irreducible minimum scenario factors in the judge's analysis.
So the tweet loses the reasonable expectation of privacy, even if when I get there you say, well, actually it's comminuted fracture, slightly displaced, and you're going to need pins.
Well, the irreducible minimum scenario doesn't include that extra evidence. That's the point in the judge's minimum common content, that it may only be a general reference to the medical condition or none at all. That's the passage I showed you in 166, I think, 3. But I ought to show you perhaps a little more of ZXC than 52, because you're right, all that's happening in 52 is as a reference to Gatley and the possibility there might be these categories of information. But if we go forward, grained upon my consciousness, having argued to this point unsuccessfully in ZXC, I sought to argue that there was no general category of allegations of criminality which attracted a reasonable expectation of privacy. That was rejected, but the treatment of the way in which particular categories may have a legitimate starting point or a general rule is instructive. If you take it up at 66, they say, before considering the ground of appeal, so I complained about the Court of Appeal saying there was a legitimate starting point, they say it's appropriate to define the general rule or legitimate starting point, which was adumbrated by both the judge and the court. First, the general rule or legitimate starting point is not a legal rule or legal presumption, let alone an irrebuttable presumption. The determination as to whether there's a reasonable expectation of privacy in the relevant information is a fact-specific inquiry. The general rule or legitimate starting point doesn't invariably lead to a finding that there was objectively a reasonable expectation of privacy in the information. Some references to the judgments below. 69. Third, the general rule or legitimate starting point doesn't obviate the need for the claimant to set out and prove the circumstances establishing that there was objectively a reasonable expectation of privacy. And then they draw the threads together, my lord, at paragraph 144, page 847 in my bundle. A determination as to whether there's a reasonable expectation of privacy in the relevant information is a fact-specific inquiry which requires the evaluation of all circumstances in the individual case. Generally, in setting out the various factors applicable to the evaluation, including but not limited to the Murray factors, it's important to recognise that not all of them will be relevant to every conceivable situation. The examination of the factors must be open-textured without being given any preordained weight. However, in respect of certain categories of information, such as the information in this case, a consideration of all the circumstances and the weight which must be attached to a particular circumstance will generally result in a determination that there's a reasonable expectation of privacy in relation to the information within that category. In respect of those categories of information, it's appropriate to state that there is a legitimate starting point, that there's an expectation of privacy in relation to that information. We prefer the terminology of a legitimate starting point to emphasise the fact-specific nature of the inquiry and to avoid any suggestion of a legal presumption, as is noted above in paragraph 67. And while it's all of a piece, there are certain categories where there's a legitimate starting point, or a general rule is the other expression used elsewhere in the judgment, that there will be a reasonable expectation of privacy. But even in those categories, that is not invariably so. And the court must look at all of the circumstances of the case, including, and this is important in the present case, the extent to which the information's already been placed in the public domain.
I mean, if one looks at the Murray factors for those, I mean, and puts that in the medical context, there's nothing there that goes very much beyond you're a claimant and you've attended a hospital and they've made notes about you.
But my lord,
And what are in the seven factors?
Sorry.
Is there anything else one could see? Because I mean, just so that you can deal fairly with this point, which is whether, in fact, medical notes might be considered to be not just something to be evaluated, but where the starting point becomes the ending point, or whether or not that's something which ought to be left over to a trial rather than on a summary basis.
Well, my submission is a very straightforward one. It would be inconsistent with the treatment of the categories of information in ZXC and Bloomberg to say that a subcategory of health-related information, namely information recorded in a medical record, invariably attracts a reasonable expectation of privacy. That would be inconsistent with the care they took to avoid any presumption or invariable outcome in relation to the categories of information they're considering.
Thank you.
Maybe going back to the reasons of paragraph 133 of the judge's judgment.
Yes.
I collected, by referring back to the earlier passages of the judgment on which she is building, the rules applicable as laid down or repeated in Bloomberg. And then the point she makes in the second half of subparagraph Roman 2 is that Mr. Pitpain's approach, that's his medical record submission, doesn't allow for that nuanced evaluation. It means that the factors that are usually part of the assessment, such as the extent to which the information is already in the public domain, are not considered. And in my submission, the judge is entirely right. His medical record submission, which is his ground 1A point, rules out all the circumstances of the case approach, rules out the extent to which the information is already in the public domain, even though that is a factor which bears upon the multifactorial assessment of reasonable expectation of privacy. Milady, the judge's next reason at paragraph 133, little Roman 3, is, in my submission, a sound one. It is a consequences submission, consequences argument or reason. She says it would be undesirable if each and every inadvertently erroneous transmission of patient data by a hospital was capable of amounting to an infringement of Article 8, however minor or anodyne the material. For example, a medical letter containing only anodyne information was sent to the wrong address by mistake. My lady, that is an appropriate consideration. The courts have recognised that Article 8 is subject to limits and qualifications which keep its demands proportionate. And can I suggest that that reason which the judge gives chimes with a passage in the Judgment of Lord Justice Laws in Wood and the Commissioner of Police for the Metropolis, which is quoted with approval by Lord Toulson in the In Re JR 38 case. That's in the authorities bundle at tab 12. The passage I want to take you to is in paragraph 86 of Lord Toulson's judgment. Just to say in parentheses, you may recall that there was a dissenting judgment from Lord Carr and Wilson in that case as to whether the reasonable expectation of privacy test remained the correct one, even where a child was involved, and the majority held that it did remain the correct test. And there were two majority speeches by Lord Toulson and Lord Clark, with the third majority judge agreeing with both. Lord Hodge agreed with both Lord Toulson and Lord Clark. But the passage I wanted to show you, which Lord Toulson said he couldn't improve on, is in the analysis of the scope of Article 8 in the Judgment of Lord Justice Laws in Wood and the Commissioner of Police for the Metropolis. So in 86, we have 3 paragraphs from Wood quoted. Can I draw your attention, please, to paragraph 22, which is quoted in paragraph 86?
Could you give me the page number?
I'm so sorry, it's 402.
Thank you.
I'm sorry, I've gone too quickly.
Oh, that's right.
To get the context, at 86, Lord Toulson's setting out 3 paragraphs from the Judgment of Lord Justice Laws in Wood. And at 22, in that quote, Lord Justice Laws summarises the effect of Article 8. The cluster of values summarises the personal autonomy of every individual, and taking concrete form as a presumption against interference with the individual's liberty is a defining characteristic of a free society. We therefore need to preserve it even in little cases. At the same time, it's important that this core right protected by Article 8, however protean, should not be read so widely that its claims become unreal and unreasonable. For this purpose, I think there are 3 safeguards or qualifications. First, the alleged threat or assault to an individual's autonomy must, if Article 8 is to be engaged, attain a certain level of seriousness, one of the ways of putting the threshold of seriousness. Secondly, the touchstone for Article 8.1's engagement is whether the claimant enjoys on the facts a reasonable expectation of privacy in any of the senses of privacy accepted in the cases. And then absent such an expectation, there's no relevant interference with personal autonomy. And then he goes on to deal thirdly with the possibility of justification. But what I draw attention to that for is that the threshold of seriousness and the need for a fact-sensitive, reasonable expectation of privacy are safeguards or qualifications which limit the application of Article 8. And the judge's reasoning in subparagraph 3 of paragraph 133 in my submission chimes with that explanation. Maybe in the judge's 4th reason, in subparagraph 4 of paragraph 133, she deals with the authorities which she's referred to above at paragraphs 71 to 76. This is another case, another situation where one has, in order to be fair to the judge, to go back and look at the cases which she has digested, because she mentions ZC and Underwood here, but she builds on a longer line of cases about health data. If we could go back, please, to paragraphs 71 and following. 71 refers to Finland, Z and Finland, which I'm going to come to specifically in a moment, if I may. But 72 and following refer to a line of domestic cases, all of which the judge rightly says establish that even in the case of health-related data, there is a range or spectrum. And they start with the well-known passage in Baroness Hale's judgment in Campbell and MGN at 157. I needn't turn it up because the judge sets it out. Not every statement about a person's health will carry the badge of confidentiality or risk doing harm to that person's physical or moral integrity. The privacy interest in the fact that a public figure has a cold or a broken leg is unlikely to be strong enough to justify restricting the press's freedom to report it. What harm could it possibly do? That appreciation that there is a range, even in the case of health data, and that, by reference to the public figure, the publicly accessible presence of a medical condition is a relevant factor, supports the approach taken by the judge. But it doesn't end there. In NT1 and Google, that passage was quoted by Mr. Justice Warby, as he then was, tab 15 of the authorities bundle. Paragraph 145 on page 545. This was the right to be forgotten case, you may recall, NT1 and NT2 against Google, and one of the factors which the judge was considering was the sensitivity of the information, some of which related to NT1's health. The judge says, picking it up 4 lines down, 5 lines down, or even 6, the health information in this case is not of any great weight, however. It's old, it's out of date, and doesn't of itself demand delisting, reference to delisting the internet search results in the right to be forgotten context. Not all disclosures of health data call for the same treatment, and then he sets out Ernest Hale's words, paragraph 157 of Campbell. The health information in this case is different, but the same can be said. NT1's evidence contains no complaint of any separate or distinct harm that is said to result from the disclosure of that information, which would surely not have, he would surely not have complained of in isolation. So,
could you just remind me of the context of what's being discussed there, the data?
What's being discussed is...
On the facts,
you may remember that the Google Spain case before the Court of Justice established a right to be forgotten before the GDPR was in place. And the 2 claimants in the case, NT1 and NT2, were both businessmen who wished Google to delist certain search results about offences which they'd committed many years in the past. And the Article 29 Working Party had produced some guidance.
No, I follow that, and I just wonder what the health information was.
Oh, I'm sorry, I can't immediately remember.
Because he's dealing with it in 145. I just couldn't remember what it was.
Could I come back to that? I can't instantly remember what it was. What I get from it is that Baroness Hale's reference to the public figure with a cold or a broken leg doesn't exhaust the range. It was different, but nevertheless, without some indication of the likely harm. As the judge says, not all disclosures of health data call for the same treatment. It's the range point which the judge gets. And our submission is solidly established in domestic law. And one needs that context when you come up to the more recent cases that Mr. Pitt-Payne showed you, the ZC case decided by Mr. Justice Julian Knowles, and the Underwood and Bounty case decided by Mr. Justice Nicola, both of which involve health data, and in the first of which the judge says, Mr. Pitt-Payne showed you, and perhaps I'll just take you back to the paragraph. Yes, if we go forward in the authorities to tab 16, page 606.
Can I just ask you, before you go to those ones, what's your submission about what Mr. Pitt-Payne said? Well, he said, well, those are all very interesting, may well be right, but they're not in the context of medical notes. They're just about other information that may be published about the fact you've got a broken leg or whatever.
Well, 2 points.
Yeah.
If the public figure in Baroness Hale's example went to hospital and a note was simply made of their name, the date of their attendance, and the fact they had a broken leg, it would be no more private for being written down at the hospital than it is absent that fact. The information remains the same. And the second point, I think I've really made already, but I'll make it again. Mr. Pitt-Payne's argument has to treat health information recorded in a medical record as a special subcategory of health-related information to which the normal tests, including public domain, simply don't apply. So he's right to say that the two cases I've shown you all so far, Campbell and NT1, were not a hospital context. But the 2 more recent cases are a hospital context. And if we go to paragraph 170 of ZC, tab 16, we see the passage which my learned friend showed you at 170. There are 2 important points in the passage. One is a dictum, but the other is ratio. Of course, it's not binding on this court, but the dictum, and I accept
Is this the decision of Mr. Justice Julian Knowles? Did you say? Sorry, which case are you looking at?
Yes, this is Mr. Justice Julian Knowles at first instance.
And page number?
Page 606, ma'am.
Yes.
I'm sorry, lady, I'm trying to go a little fast, but I'm very conscious of the,
All right.
the time. There are 2 points in this paragraph, are there not? There is a dictum, and the judge recognised it was only a dictum, where he says, I entertain doubts that the mere fact of a person's attendance at an A&E department would without more constitute private information. That's a dictum, but in my submission it is consistent with the run of authority I've shown you. He says, I don't need to decide, we've read the word in this morning, I need not decide, perhaps what it means to say that in this case. And this, what he goes on to say is important because it applies the public domain consideration to information recorded in a hospital context. He says the reason this claimant doesn't have a reasonable expectation of privacy is because she's chosen to make that fact public when she applied for the summons in the private prosecution. So it makes good, the dictum supports my submission about range and the judge's conclusion about range. The holding supports my submission about public domain being a relevant factor even in the case of information recorded in a hospital context.
Can I just ask also whether that, the publication, which obviously doesn't happen in every case, but we all know that it does happen in some, is that a defence or an element of the tort? Because I think it's accepted that you can have these type of representative actions where there are different limitation defences available to some and others. And if only some people might tweet about going to hospital, how does that leave the others?
It's not a question of a defence. The claimant has to make out a reasonable expectation of privacy on the basis of facts personal to them. We saw that, my lord, in ZXC, I think it's 60, either 67 or 69. Even in the case of health information, the claimant has to make out the facts which give rise to the reasonable expectation of privacy.
Thank you.
So my lord is right, and there's some discussion in the authorities about whether, if there's a defence to some class members, a representative action can still run. I ran a different point. I did run that point, but the judge found against me on it, but I ran a different point, which was all of the members of the class have to be able to establish a viable claim, one element of which was a reasonable expectation of privacy.
Thank you.
Just before I go to the next case, Mr. Craven reminds me that the reason I was struggling to immediately find a reference to the health information was because this is the open judgment in NT1. The closed judgment had the details of the health information in it. So even if I could remember it being proper of me to say in open court what it was, but the...
Especially with live streaming.
Especially with live streaming. So I won't explore that any further. That's very helpful just to remind me of that before I put a foot wrong. All we learned from the
Mr. Craven.
all we learned from the open judgment is that it was historic and not particularly serious. The next case I wanted to go to, the second of the modern cases that Mr. Pitpain showed you, is Underwood and Bounty. That is in tab 21. Thank you. And the page for the start of it, my lady, is page 764. Mr. Pitpain fairly showed you paragraphs 52 and 53, which are the reasons, plural, for dismissing the claim. The first is that there had been no misuse of data by the hospital as opposed to the commercial organisation. But in my submission, what Mr. Justice Nicola squarely does at paragraph 53 is to provide a second reason why the claim would fail anyway. Maybe this is page 779. the case is important because, again, it's information recorded in a hospital context, improperly accessed by the baby goods provider. Even if the claimants had established the second defendant was liable under the MPI tort for bounty acquiring information about them, the information so obtained was trivial, discounting the information the first claimant had already provided to bounty voluntarily when she originally signed up for its products and services. This amounted only to the name, gender and date of birth of the second claimant. To be actionable for misuse of personal information, the information misuse must reach a level of seriousness before the tort is engaged. Had the claim not failed for other reasons, it would have failed on this ground. Now, the judge says it's doubtful whether that is obiter, and I respectfully agree. It is a second reason why the claim fails. And it is about the application of the threshold of seriousness and the triviality of the information to information recorded in a hospital context. And so, my lady, the judge was right in our submission at subparagraph 4 of paragraph 133 to say the cases don't support Mr. Pitcairn's suggested distinction, even if the judicial observations in Z.C. and Underwood were obiter, which I doubt in the latter case. They clearly support the opposite proposition, namely a spectrum exists in relation to information generated by the doctor-patient relationship, such that information may be so anodyne or sufficiently in the public domain already that no reasonable expectation of privacy arises. My lady, I haven't yet dealt with the last of the cases cited in paragraphs 71 through 76 of the judge's judgment, and I'll do that now. That's the Z and Finland case. The judge refers to it in paragraph 71, and it's an authority my learned friend cited to you this morning. He didn't, however, take you to the case itself because he'd set out a passage from it in his skeleton. I don't criticise him for that, but the passage set out doesn't include the part I want to show you. Z and Finland is tab 26 of the authorities bundle, starting at page 899. Relevant paragraph is paragraph 95, page 933, my lady.
Thank you.
Mr. Pitcairn fastened on the first two indents of paragraph 95 and the importance of the protection through Article 8 of medical records. No quibble with any of that. But I rely on the third indent, just before paragraph 96, on page 934, where the Strasbourg court goes on, having identified that importance, to say the domestic law must therefore afford appropriate safeguards to prevent any such communication or disclosure of personal health data as may be inconsistent with the guarantees in Article 8 of the Convention. The importance of that wording in my submission is that the threshold of seriousness and the fact-sensitive reasonable expectation of privacy are both part of and limit the guarantees in Article 8 of the Convention. The court doesn't require a greater degree of protection in medical records. It just requires that the protection is not inconsistent with the guarantees in Article 8. And once you have in focus that those guarantees are, as Lord Justice Laws said, limited or qualified by the expectation, by the threshold of seriousness and the reasonable expectation of privacy, then there is nothing which requires medical records to be treated in a way which doesn't take those factors into account. My lady, can I then go on to the fifth reason in the judge's paragraph 133. This is where the judge deals with the NHS and GMC materials that Mr. Pitpayne showed you this morning, and which he also showed to the judge. She accepts that they emphasize the importance of confidentiality in the way medical records are handled, but she says correctly in my submission that they're not aimed at identifying the circumstances in which an affected individual would have a viable civil claim, and I interpose, for misuse of private information.
Mr. Pitpayne's point was that this feeds into what objectively would give rise to a reasonable expectation of privacy.
And I agree, and so did the judge. And that's why I emphasised the conclusion of paragraph 133. She says, and I can't overemphasise this, that the medical record context, back at the introductory wording at the beginning of 133, will be a highly relevant factor to take into account when applying the all circumstances of the case test. But that's its potency.
In relation to, what about the point made in relation to Z in Finland, which is the importance of confidence, as it were, and not in using that in the legal sense, but patient confidence, and the fact that their communications with which give rise to a medical record of doctors or whatever are kept confidential.
Well, I don't quibble with that at all. But the consequences I've just shown you in Z in Finland is that they require the protection of the guarantees of Article 8. But they don't require a superadded protection that no other category of information receives. And they are subject to the threshold of seriousness and the reasonable expectation of privacy. So I accept entirely the importance of public confidence in the looser sense in the medical system, the ability to consult your doctor, the need for people with infectious diseases to come forward, all of that. We don't seek to dispute any of that. All we say is there's an established methodology for assessing whether there's a reasonable expectation of privacy in relation to categories of information, including health-related, and the medical records submission, which is binary, if it's in the medical record, there's a reasonable expectation of privacy, full stop, is contrary to that established methodology shown in authorities which were binding on the judge.
So does it come to this, when one's looking at all the circumstances of the case, and it is a medical record, there is a confidentiality attached to it. The issue then is how much weight should be attached to that.
Precisely so, my lady. And that's what ZXC says about confidentiality. Can I take you back to that passage? It's in paragraph...
Which divider?
I'm sorry, it's 23. Lady, it's the paragraph 150 and page 848. Another of my arguments that fell on stony ground was that the courts below had elided the concepts of privacy and confidentiality, and the Supreme Court squashed me very emphatically on that, but also explained the interrelationship between the two concepts at 150. They say the recognition that the causes of action for misuse of private information and breach of confidence are distinct means there's no necessary overlap between them. Information may be private but not confidential, or confidential but not private. To prove information is private is not necessary to show it's confidential. Often, however, confidentiality and privacy will overlap. Confidentiality may well be relevant to whether there's a reasonable expectation of privacy. In particular, if information is confidential, that's facts likely to support the reasonableness of an expectation of privacy. So it's exactly as my lady put it a moment ago. The confidentiality is a relevant factor, as the judge in this case expressly recognised, and it supports a finding of a reasonable expectation of privacy, but it is not invariably determinative, in particular because there are factors such as public domain which have to be taken into account. And in my submission, if you read the opening words of 133, where she acknowledges the confidentiality as a highly relevant factor with her treatment of the NHS and GMC materials at subparagraph 5, there is no error disclosed in her approach. Lady, the sixth reason is important. She has already said in the second reason, in the last half of subparagraph 2, that public domain is a factor which is usually relevant to the assessment of whether there's a reasonable expectation of privacy. The point she goes on to make in subparagraph 6 is that it's difficult to see how or why information that's already been made public and doesn't attract a reasonable expectation of privacy could become subject to such an expectation simply by dint of that information then forming a medical record. And my answer to my Lord Justice Dingemans' question about the public figure in Baroness Hale's example, attending hospital and just their name and position and the fact of the broken leg, broken arm being recorded. And that was an example. My submission would be illustrative of the point she makes in 6. But she then goes on to make an important point in the second half of subparagraph 6 about a situation which she then builds in to the lowest, to the irreducible minimum scenario. She says, for example, an identifiable person who tweets that they've fractured their ankle and are on their way to hospital before they arrive at the A&E department with this injury. So she gets the temporal focus right, in my respectful submission, to pick up a point my lady, the President, made this morning. This happens before she arrives at the hospital. She tweets her medical condition. She tweets her imminent arrival at hospital. In the judge's irreducible minimum scenario, that's all the lowest common content the medical record contains. In fact, it's rather more, because the lowest common content may not say anything about the medical condition. And if that is a realistic scenario, and it's not, I've said it's not, and I'll show you when I come to the ground 1B, that there were patients within the class who put a great deal of medical information into the public domain for good reasons, honourable, admirable reasons, but they nevertheless put information about their medical condition and treatment into the public domain. And the judge, because she's dealing with a lowest common denominator claim, has to factor in that feature of some patients' individual situation. I'll come back to what she says in 135 about public domain when I deal with round 1B. So I've dealt with the judge's conclusion and reasons, and in my submission they are orthodox and fully consistent with binding authority. And it's not my submission that no member of the class might have had a misuse of private information claim. That's not the judge's focus. She's got to focus, after Lloyd and Google, on the lowest common denominator.
Well, I mean, you would say that the lens through which we must regard this case is a question of whether or not it's a representative claim can be allowed to continue. not on whether or not there are viable claims within the categories identified by the claimants. We call it that.
Precisely. That was the case, as you'll recall, in Lloyd and Google. It was the lowest common content of the claim which ultimately caused it to fail in the Supreme Court. So, maybe before I leave ground 1A, there are certain specific points made in the reference skeleton which were also touched on this morning. Paragraphs 31 to 33, he refers to Z and Finland, which I hope I've already dealt with. In paragraph 34, he refers to the NHS and GMC materials, which again I've addressed. He then, and this was a point he repeated before you this morning, he raises the possibility at paragraphs 35 and 36 that the patient may not or will not know what information is recorded in the medical record. And then we say, true, but so what? If the patient doesn't know what is in the medical record, that cannot make information which is not private, but is recorded in that record, into private information. That would be alchemy. It may be a reasonable point to make about what happens in practice in relation to medical records, but it doesn't meet the points I've been making about the content of the information and the other factors which have to be taken into account. And then finally, in relation to ground 1A, Mr. Pitpayne says in paragraph 38 of his skeleton that the judge only referred to the Murray factors of paragraph 67 and didn't come back to them when constructing her irreducible minimum scenario. It's a short point, but that's not a fair criticism. The judge specifically returned to the Murray factors and considered the claimant's submissions in relation to them at paragraph 122 of her judgment in the approach to her arriving at the irreducible minimum scenario. So there's no error there from my perspective. Unless there's any point on ground 1A that I've not dealt with, I was going to keep going.
Can I just ask one point on ground 1A?
Of course.
Which is how it relates to the class at page 45 of the our core bundle, where there's classes 1, 2 and 3. Mr. Pitpayne said to us that in fact all of those points related only to class 1 rather than 2 and 3. Is that common ground?
It wasn't explored in great detail at trial because that point wasn't made. It was never suggested that the claimant wished to bring a claim only on behalf of categories 1 and 2. And the judge explains, may help to just explain why she focused on category 1. You see that in paragraph 162 of her judgment.
Yeah.
She refers to the definition of the claimant class. And then she says, you see three lines down on page 117, for present purposes I'll focus on those who attended a hospital or other medical service, as this appears to be the largest cohort. Now, the real world significance of that, my lord, is the claimant, even now, doesn't want to drop class 1, despite my lord giving him 2 opportunities to do so, because it's class 1, which is the numerous class for the purposes of the litigation fund.
I understand he doesn't want it, you don't want it, but our job is to give a result according to the law, as we find it to be, obviously in an adversarial system. Well,
no, it wasn't. The point I made, or I began to make, and perhaps I should have put more emphasis on that, is it wasn't explored before the judge, because it was never put to the judge that the class could go on as 2 and 3. 3 emerged only very late in the piece, when Dr. Hughes' second witness statement was served, and it was added without objection shortly before the hearing. 2 appears to be those who have an X-ray, a radiology record. But it was never, there was no argument before the judge about the minimum content of classes 2 and 3, which would appear to be X-rays and blood test results. The claimant, for the purposes of the representative action, needed one apprehends category 1, and the judge wasn't invited to consider leaving only categories 2 and 3 and chopping off 1. So she can't be criticised for that. It wasn't an invitation made, and even today, it's not an invitation made to you. I fully understand my Lord's point about this court getting the right result, and that's obviously how the system works. But where it's not the claimant's case that they wish to proceed 2 and 3, and it wasn't explored below because it wasn't this case there, in my submission, the purity of the legal outcome doesn't drive you to consider just excising category 1.
Thank you, and sorry to interrupt.
Not at all. In fact, I was glad to get the opportunity to explain why the judge had focused on category 1 in paragraph 162. Ground 1B, the court erred in rejecting the submission that the placing of equivalent information in the public domain by a patient doesn't affect, and then the wording runs on to specify 2 different things, does it not? Doesn't affect either 1, a doctor or healthcare provider's obligations to keep private the information generated in the context of their relationship with patients, or 2, the reasonable expectation of privacy attaching to that information. As we point out in our skeleton, those are 2 different things. The obligations of the healthcare provider are not an issue in this case. What is in issue is the reasonable expectation of privacy for the purposes of the tort of misuse of private information. And that's important, an important perspective, because most of Mr. Pitpain's argument, particularly in his written argument, focuses on the first of those 2 points, the impact of publicity on the healthcare provider's obligations, and he showed you the bit in Caldecott 2 about the social media user. But that isn't the right perspective, it's not the right target. The target here is the information in relation to the particular information for the purposes of the tort of misuse of private information. I showed you a moment ago in paragraph 133, subparagraph 6, the judge's example of an identifiable person tweeting that they'd fractured their ankle and were on their way to hospital. And when she comes to construct her irreducible minimum scenario at 166, she refers back to that in subparagraph 166, little Roman 5, information relating to the hospital attendance was otherwise in the public domain, which could have arisen, for example, because of the attendee posting the information on social media, and then she refers back to the paragraph where she made that point. But my lady, it's not just the judge's example. As she says, I'll take you back to paragraph 135, as she says under the heading, information already in the public domain, picking it up in the middle of 135, she says, I've just referred to the example of a person choosing to place information about their medical condition and or hospital visit on social media. That's a reference back to her 6th subparagraph under 133. And then these important words, in addition, the defendant's evidence includes examples of grateful patients publicising in the media the treatment they were able to receive following the detection of AKI. Can I just show you very briefly what that material, or some of that material consisted of? If you could go in the supplemental bundle, please, to page 282. Is a post on the Royal Freeze website about a patient called Mazafia Ahmed, whose name appears at 283, explaining that the Streams app had sent an alert which had resulted in a very beneficial effect in the medical treatment which she received. Pick it up at 283, just above the blue line, about a quarter of the page, quarter of the way down the page. One patient who had the benefit of the new app is Afia Ahmed, 38, from Hampstead, who suffered complications following the birth of her daughter Eliza by emergency caesarean last month. Afia developed sepsis, an infection in the blood during her labour, which then led to AKI. Using data from Afia's blood test, the Streams app detected a problem with her kidney function, and an alert was sent to a specialist kidney doctor. And then it goes on to explain how that benefited her treatment, and includes a quote from the patient. And the same patient went on to give an interview to the Evening Standard, which we have at page 286. Where again we see her photograph and then description of the same medical problems which she experienced and the way in which the alert from the Streams app resulted in treatment which was of great assistance. Again, includes quotes from the patient. That's one example.
These were exhibits to whose witness statement?
Miss Dr. Hughes' second witness statement.
Thank you.
It didn't rest there. We discovered shortly before the hearing that the claimant, Mr. Prismall, for no doubt good reasons, had chosen to put his own medical information into the public domain, and the relevant documents start at page 290 of the same bundle.
Would it be necessary when dealing with a case, assuming that it was an individual case for a moment, to distinguish between somebody talking generally about, for example, the fact that they've got cancer and the particular type of treatment, the specifics that are given in the medical record, for the purposes of the public domain argument?
If the judge was looking at a particular individual and looking at the information placed in the public domain as against what was recorded in that person's record, then that point might become important. But she's not. She's looking at the lowest common denominator. And because of this material and her social media example, she has to make the assumption that all of the low-level information contained in the medical record of the lowest common denominator had been placed in the public domain. So one isn't doing a comparison of detailed clinical information about treatment with a generic reference made public. And that point's very important when one comes to ground 3, because the judge asked rhetorically, how could you remove from the class those people who'd placed their medical information in the public domain to a particular extent? How would you draw that line? So the point my lady puts to me has great force if you're comparing, in the case of individual claimant C, what their medical record showed and what they placed in the public domain. But when you're considering the irreducible minimum scenario, where the person's medical record has the lowest common content, identified in paragraph 166, and the highest level of putting information in the public domain, which the judge says is all of the information contained in the medical record, you see how important those building blocks are in her irreducible minimum scenario.
Because in Lloyd and Google, Lord Leggett did suggest that this scheme shouldn't be squashed just because it was an old representative action. There seems to be a great deal of effort and intellectual power being brought to bear to say, aha, this person might not have a viable claim, and just identifying it, and then saying, and therefore that's the end of it.
Well, 2 points for me. At the last run of paragraphs in Lloyd and Google, is exactly the same intellectual exercise which I'm engaging in, which is to look at the lowest common denominator claimant in the Lloyd and Google class and see whether that person has a viable claim. What Lord Leggett essentially said, as I read Lloyd and Google, is the representative action should be applied flexibly and it should be made to work in modern situations. It can do that for remedies such as a declaration or an injunction, which benefit the whole class. It can do that for damages where either there is a specific sum sought by each member of the class, or they have a damages claim which is calculated on a common basis, such as an identical defect in a product which they bought. Or it can sometimes work as a bifurcated claim, where liability is decided but quantum claims come on afterwards. Or it can work as what Lord Leggett called a top-down claim, where you claim a global sum for the whole class. But none of those ways of using representative action, which incorporate the flexibility which he undoubtedly wanted to give it, apply in this case. And the judge goes through all of that in great detail in her analysis of Lloyd, which we haven't been looking at because it's not germane to any of the grounds of appeal. But I do commend it to you, and I have every confidence that you will have read it and will read it again. When the judge goes through Lloyd and Google, she explains all of those flexibilities and limitations and explains why the claimant doesn't seek to take advantage of any of the ways Lord Leggett said a representative action for a financial remedy could go forward. Instead, this claimant seeks to do what the claimant did in Lloyd, which is to run a lowest common denominator claim, which has to be analysed on the basis of the irreducible minimum harm. So I don't shirk from what my Lord has indicated as a great deal of intellectual effort. Lord Leggett's flashlight shone my path, and I submit, as I did before the judge, that if you follow Lloyd and Google to the end of the road, you get the same outcome as occurred in that case. And that's ultimately what the judge held. Lord, if you want me to, I can go through Lloyd and Google in detail, showing you those passages.
I don't think it's necessary. I think we've obviously all read the judgment more than once, and we're familiar with both the case and the analysis of Lord Leggett and the judge's further analysis in this case.
I meant it when I said I was completely confident of that.
Yes.
I'm just seeking to answer shortly what my Lord said about the intended flexibility. That's right, but it has limits where monetary remedies are sought.
Thank you.
I probably don't need to labour the point about the claimant's medical information. Admirably, he'd sought for reasons of both encouraging organ donors and fundraising reasons to put into the public domain information about his medical condition, the treatment he received at the Royal Free, and the like. And those documents are at pages 290 through 293 of the supplemental bundle. And I mentioned that to make good what the judge says at paragraph 135 about there being evidence of individuals within the class who had put their medical information about their medical treatment into the public domain. I showed you earlier that the judge had noted expressly that the requirement to take into account the extent to which the information is already in the public domain, paragraph 68 of her judgment, drawing on paragraph 54 of Lloyd, of ZXC and Bloomberg. The only additional point which my learned friend makes, apart from saying that public domain is irrelevant to this category of information, even though it's relevant, it appears, to all others, is that the disclosure by the patient will not be granular and highly structured. So it's similar to the point I think my lady was putting a moment ago about the details that may appear in the medical record. Lady, that fails to grapple, that submission, with the judge's findings in her irreducible minimum scenario about the lowest common content of the medical record and the extent to which some members of the class, the lowest common denominator member of the class, will have put information about their medical condition and treatment into the public domain. The public domain point is particularly important, and I trail this now. One of the judge's reasons for refusing to allow an opportunity to amend was that she couldn't see how the class could be adjusted to deal with those members who put, as she put it, their medical information into the public domain to a certain degree. She couldn't see practically how that could be done. And you may have noticed that in the new proposed amendment at page 42, there is no attempt to grapple with public domain, even though it was one of the specific reasons why the judge said she couldn't see how the problems she'd identified. So I said 42, 45, I'm sorry. Even now, the claimant cannot see a way to remove from the claimant class those members who put their medical information into the public domain, and doesn't even try. Let me now move to ground 1C. It said that the court erred by adopting an impermissibly wide definition of direct care and or failing to address the full scope of the claimant's case on use by the defendants of the information that was transferred. That again analytically throws up 2 points. One is an impermissibly wide definition of direct care, and the second is a failure to address the full scope of the claimant's case on use by the defendants. Now focus first on direct care. The judge's findings on direct care feed through into her irreducible minimum scenario at 166, subparagraph 6. She'd moved from public domain, which is subparagraph 5 of her irreducible minimum scenario, to whether any of the uses to which the information was put went beyond direct care. And she held that there was a realistic argument of showing that 2 of the uses complained of, namely the transfer of the medical records and some part of their period of storage. The data was transferred to the second defendant, stored in circumstances in which there's a reasonable prospect of showing went beyond direct patient care. And she refers back, again, it's the structure of the judgment, to paragraphs 146 to 147, where she went through whether the transfer was covered by direct care, and essentially held that because at the time of the transfer, what was envisaged was a wider collaboration than just streams, that transfer in those circumstances wasn't covered by direct care. Similarly, part of the period of storage of the data, and she made an assumption favourable to the claimant that it was at least 12 months, was also not within direct care. Now, my first submission is it's unrealistic to suppose that if the judge had considered that one further stage, it's called normalization, in which the data is put into a particular format where it can be used in the app. If she had thought that that wasn't covered by direct care, it is in our submission idle to suppose that that would have affected the outcome of her irreducible minimum scenario. She'd already found that 2 substantial uses weren't covered by direct care. A third, normalization, wouldn't have affected the analysis. If we're wrong on that, we say that her findings on normalization, which are made at paragraphs 146 and 148 of the judgment, are sound. The ultimate direct care, which is accepted, the app provided after February 2017, couldn't have happened without normalization. That was common ground. And in our submission, she was right at 146 and 148 to say that for that reason, normalization, whenever it occurred, was covered by direct care. That leaves only one other stage, which I'm afraid is a little detailed, and I apologise for this. That is the clinical safety and effectiveness testing. Can I start by making a very important point, which caused concern on our side of the court when it was put inaccurately this morning. The development of this app was not undertaken using patient data. It was undertaken using synthetic data, as the judge finds in her judgment. That included the testing stages prior to the stage called clinical safety and effectiveness testing. All prior stages had used synthetic data.
Did you say it included the testing stages?
Yes, it included the testing stages prior to clinical safety and effectiveness testing. Perhaps I'll take you in the judgment. If we go back to 150 in the judgment, just to make good the point I've made about the use of synthetic data. The judge says, I turn to Mr. Payne's third area of alleged misuse, described as using the medical records in the research and development of the Streams app. However, the representative claimant doesn't dispute or identify material that gainsays Dr. Hughes' account that all stages of testing prior to the on-site clinical safety and effectiveness testing used fictitious data rather than real patient data. So it's only when you get to the clinical safety and effectiveness testing stage that the data is used. And the dispute between the parties is a narrow one in relation to that data. The claimant says, by reference to the ICO letter dated the 3rd of July 2017, that all 1.6 million patients' data was used for clinical safety and effectiveness testing. The judge found as a fact that only the data of a small cohort of patients, 200 or 300 in number, was actually used for that stage of testing. And that the Information Commissioner's letter, because it didn't focus on what actually happened at the clinical safety and effectiveness testing stage, made a broad but incorrect reference to 1.6 million patients' data, all of which had been transferred before that stage of testing.
That resolution of that sort of factual dispute seems to me to be a function for a trial rather than a summary one.
Well, the judge considered that carefully, my lord, and in my submission, there's no reason why on a summary determination, if there is a clear answer, as the judge found there was in this case, the judge shouldn't grasp the nettle and decide it. She was pressed with exactly that argument. But there's actually a simple way through this. Once you see what the judge found the clinical safety and effectiveness testing to involve, it is impossible for it to have used the data of more than a small cohort of patients. We need to start, and it's another of these situations where she refers back to earlier paragraphs. We need to start at paragraphs 43 to 45 of the judge's judgment. Just in passing, you see at 41 the findings that fictitious synthetic data was used for the stages of testing called pre-deployment testing and system integration testing. She then describes what normalization means at 42, which I touched on briefly. And then she says, importantly, at 43, what on-site clinical safety and effectiveness testing involved, done in various windows during the period December 2015 to December 2016. The purpose of this testing was to ensure that there were no particular issues with the Royal Freeze systems which had not been identified and resolved during the earlier phases of testing. A side-by-side comparison was undertaken between a clinician identifying AKI through routine clinical practice and the outcome generated by the pre-release version of streams. By its nature, this phase of testing did involve the use of real patients' data. Dr. Hughes said that it only concerned patients who were being treated by the renal team during the relevant periods, and he estimated that the data of roughly 200 to 300 patients would have been involved. And she sets out the point made in Dr. Hughes' second statement that by the time that testing was undertaken, all of the patient data had been transferred and would have been present in streams, but only the 200 to 300 patients referred to would have had their data accessed. And my lord, she comes back to that at 150 to 158. But the important point is the one which emerges from 43, which isn't in dispute, which is that what actually happened during the clinical safety and effectiveness testing was that there was a side-by-side comparison of the information thrown up by the app and the information retrievable from the traditional sources of medical record. And that happened only in relation to a small cohort of patients. So she comes back to that point, you see at 151, picking it up 4 lines down. Furthermore, the patient-identifiable medical records that were accessed during this phase of testing were those of a relatively small cohort of patients who attended the Royal Freeze renal team at the time for treatment, and whose records were accessed via the pre-launch streams alongside their clinician accessing the same records containing the same information via the Royal Freeze existing means for doing so. There's no dispute that that was what clinical safety and effectiveness testing consisted of. And that's why the judge says in 152, I conclude the use of this limited cohort of data for the purpose I've referred to was clearly an aspect of direct care. And then she refers to the National Data Guardian's correspondence. Says at 154, the exact number of patients whose records were accessed via streams as part of this phase of testing is not known, C43 above. However, the conclusion I've expressed in 151 to 152 would apply to the patients in question, whether it was 200 to 300, as Dr. Hughes estimates, or a different figure. And the reason for that is, unless it's every single one, you don't build it into the irreducible minimum scenario. And so when she comes to construct her irreducible minimum scenario, she says, the lowest common denominator member of the class did not have their data used for clinical safety and effectiveness testing. But in any event, she says, it fell within direct care. And my lord, She goes on at 155. In any event, the cohort of patients who were treated by the renal team during the period of this side-by-side testing is clearly a very small number relative to the entire claimant class. And then she says that Mr. Pitpain's answer to that is to refer to the ICO letter. She then analyses the ICO letter at 156 to 157 and concludes, accurately in our submission, the letters before the court, that the letter doesn't identify the various stages or the way in which real patient data was or was not used at each stage of the process. There's thus nothing specific in this text to gainsay the account given by Dr. Hughes as to what was done at each of those stages and the use of synthetic data, nor does the ICO's letter describe how patient-identifiable data was used in the clinical safety and effectiveness testing. So there's nothing in the letter which directly contradicts Dr. Hughes' explanation of the nature and extent of the use of patients' medical records at this juncture, referring back again to 43 to 44. And so, whilst I, of course, recognise that disputes of fact are commonly unsuitable for determination, the judge here carefully analysed whether there was a basis in the ICO letter for undermining or treating as unestablished Dr. Hughes' evidence, recognising that the specific number didn't matter. What mattered whether every patient's data was used for that testing, and it clearly wasn't, because it's only a small number of patients who were treated by the renal unit at the material time. And therefore, not only is that not something which requires a trial, the judge's answer is, in our submission, plainly correct. This very small amount of material didn't turn on a large amount of documents or conflicting witness testimony. It turned on a letter and an account of what the testing in question actually consisted of.
I mean, I don't want anything I say to detract from the clarity nor indeed the importance of the ICO's letter. But it was looking at topics, if you like, and it was taking a broad approach, which may have been necessary given the context of the letter. And that's then what the judge took from it.
Well, my dear, that's exactly right. It wasn't written as an analysis of how many patients' data was used for each stage of testing. And so it's not a criticism of the ICO's letter. That wasn't its target. And I entirely accept that. I'm grateful. Lady, the second limb of ground 1C, moving from direct care now to the judge failing to address the full scope of the claimant's case on use. In our submission, this is a quite unfair criticism. The claimant, Mr. Pitpain, explained to you this morning, and you no doubt jotted down, the 4 categories of alleged use. Only 3 of those were pleaded. The 4th wasn't pleaded. I made a mild protest, but the judge said that that could be cured by an amendment, rightly. But she set out in paragraph 3 of her judgment the same 4 categories of alleged misuse. To match what Mr. Pitpain listed for you this morning, obtaining patient-identifiable medical records in a context where they being Google, a contractual commitment to use them for purposes wider than direct patient care and or wider than the Streams project. Secondly, storing them in those circumstances. Thirdly, using them in the research and development. And fourthly, developing and improving general capability by use of the medical records with a view to enhancing their future commercial prospects. If you go to 21, you'll see the disposal of my pleading point. Last 3 or 4 lines of 21. For the avoidance of doubt, insofar as the pleading doesn't clearly identify the alleged interferences that Mr. Pitpain relied upon at the hearing, paragraph 3 above, I accept this could be addressed by amendment to the pleading. So the claimant was allowed to run its full case, even though it went beyond its pleading on use. The judge then analysed the alleged uses in great detail at paragraphs 139 and following, and upheld Mr. Payne's submission that you had to look at the purpose of the transfer of the data at the time of transfer rather than the purposes it was ultimately used for. So Google lost on that point, and the judge said, I'm going to look at the wider collaboration envisaged in the information sharing agreement and the MOU. And then at 141, the judge dealt with the fourth category of alleged use. She said it's convenient to indicate at this stage that I do not consider that the representative claimant's fourth alleged wrongful interference with patient-identifiable data, paragraph 3.4, is capable of amounting to a freestanding instance of misuse of information. The usages of patient data the representative claimant relies on are those identified in 3.1 to 3. I've just accepted the defendant's purpose at each of those stages is relevant to whether a reasonable expectation of privacy then existed in the information. However, although there's some lack of clarity over the date when the defendant's plans changed, the representative claimant doesn't identify any additional instance of wrongful use of the patient data and doesn't raise anything to gainsay or undermine the defendant's evidence that it wasn't used in any other way. So to summarise, she rejected Google's submission that you looked at the purposes for which it was ultimately used. She said, no, I'm going to look at the purpose envisaged at the date of transfer, which is the wider commercial purpose. And then coming back to that when she constructs her irreducible minimum scenario at paragraph 166, I've already shown you Little Roman 6, transferred to the second defendant and stored in circumstances in which there was a realistic prospect of showing went beyond direct patient care, referring back to 146 to 7, and then the period of time she assumes. And then at 7, she continues, at the time of the steps referred to in the previous sub-paragraphs, that's the transfer and part of the period of storage, the defendant's intended purpose for the data related both to Streams app and to a wider collaboration with the Royal Free that would be financially beneficial to the defendants. But the information was not in fact used in that broader way, referring back to 141. So she has, it's quite wrong to say that she didn't address or engage with the full case on use. She accepted the first 3 uses, and that at the time of the first 2 in any event, there was a wider collaboration for commercial purposes intended. And that is built into and recognised in the irreducible minimum scenario. So in our submission, there's nothing in that second half of ground 1C that she didn't engage with the claimant's full case on use. My lady, ground 1D is surprising, and Mr. Pitpain didn't say, although he does in writing, he didn't say orally, although he does in writing, that it's an argument that wasn't advanced before the judge. The argument, in essence, is that the judge should have construed the definition of the claimant class as requiring one or more of the elements in paragraph 58 of the appeal skeleton argument. And that unless there was one or more of those elements in paragraph 58 of the appellant skeleton, the judge ought to have concluded that the individual in question wasn't within the class. Lady, not only was that point not made to the judge, as I showed you when I stood up shortly after 2 o'clock, the claimant explicitly accepted the defendant's evidence as to the lowest common content of the transferred records. I showed you that at 163 and 180, subparagraph 3. So there was no scope for the judge to interpret the class definition as requiring one or more of the elements in paragraph 58, which is now said she should have done. And it's a new argument. It's one the judge didn't have an opportunity to consider. And in our submission, it's a poor argument. The current proposed amendment of paragraph at page 45 of the core bundle seeks to build in the list of factors in paragraph 58 of the skeleton, which this argument assumes were there anyway, without being expressly set out. And as my Lord Justice Dingemans pointed out on 2 occasions to Mr. Pipane this morning, the first factor in paragraph 58.1, now the first factor at paragraph 45, in fact went no further than the judge's lowest common content of the medical record. Medical records, you see this at 45, medical record refers to a record including one or more, so any of what follows is sufficient. A, the fact the patient had attended a healthcare provider and or been seen by a particular clinician. But when it was and or, I understand it's now a retreat from that and the word or is being removed, but when it was and or, it went no further than the judge's lowest irreducible minimum scenario finding on the content of the record. Takes me to ground E, ground 1E. Lady, I'm going to deal with this briefly. It said that the judge was wrong to include in paragraph 166 that the data, the patient, lowest common denominator patient, was caused no upset or concern. Not an error to include that. She could just have left it out. It would have made the position of the lowest common denominator claimant more serious had there been upset or concern, but it didn't affect the analysis to simply note that there was no upset or concern. It's really not a point of substance in our submission. We do cite at paragraph 48 of our skeleton the consistent case law that shows impact on the claimant, which is after all one of the Murray factors, is relevant to reasonable expectation of privacy. The judge is hardly to be criticised for recording that there's no impact in her irreducible minimum. Lady, ground 2, as my learned friend fairly accepts, raises no separate issue of substance. The skeleton says it follows from ground 1, and then if ground 1 is well-founded, ground 2 succeeds. Lord Justice Warby, giving permission to appeal, said that the ground 2 raised a separate issue of substance, and we respectfully agree, and it's not been put forward that it does. Ground 3 is a case management decision by the judge, not to give the representative claimant another go at formulating the case. It's important to remember that the case you're currently dealing with wasn't the first case brought by this representative claimant based on these facts. After the decision of this court in Lloyd and Google, Mr. Prismall started a representative action claiming compensation for breach of the Data Protection Act and claiming compensation for each member of the class under Section 13. When the Supreme Court allowed the appeal in Lloyd and Google, that case was abandoned and the defendants were left out of pocket. His second go was the case that you now have before you, which is to use precisely the same facts, but to say that each member of the class has a misuse of private information claim. And I emphasise that because when the judge says it's not common to allow a litigant a second go, in fact, if he'd been allowed an opportunity to amend, it would have been a third go. Our submission essentially is that this was a case management decision, as the judge records in her judgment. It isn't said that she took into account an irrelevant consideration or left out of account an irrelevant one. The representative claimant has to say the decision was plainly wrong. Plainly wrong means outside the reasonable ambit of disagreement open to first instance judges. And it's a very exacting test on appeal to say that a case management decision is plainly wrong. The claimant took a tactical decision not to produce a draft amendment. In his opening skeleton before the judge, Mr. Pitpayne said, if the application is otherwise successful, I'll want to try and amend. I immediately put a marker down. I'm afraid I'm quite long in the tooth. And I said, if you want to amend, please can we have a draft of the amendment? And we can consider it and argue over whether it meets the objections which I was making to the existing case. That fell on stony ground. And it was a strategic decision not to proffer an amendment, but to wait instead until the judge's reasons were available before seeking to reformulate. But the judge didn't decide against Mr. Pitpayne on that point. She set out at paragraph 185 a series of reasons which, in my submission, are compelling case management reasons for the approach that she took. She said at 1, the difficulties the representative claimant faces are inherent in seeking to bring this claim as a representative action when necessary components of establishing both liability and the remedy sought, a reasonable expectation of privacy and loss of control damages, would usually be assessed on an individualised basis, and in the present circumstances many relevant variables exist between members of the claimant class. Representative claimant accepts the representative actions only permissible if all of the individualised circumstances of those in the represented class are left out of account. However, taking a global irreducible minimum approach in circumstances where there are so many variables means that even with some narrowing of the class, it's very unlikely that it can be said that any given member of the class will have a viable claim with a reasonable prospect of success. And then she builds on that. The lowest common denominator approach means that individualised characteristics and situations that could strengthen the claim or increase the likelihood of damages have to be left out of account. This would remain the case if the claim was amended and narrowed. For example, the question of whether there was a viable claim across the class would still have to be approached on the basis of the most anodyne medical record that could apply to the redrawn class. And then these important words, and the assumption would still need to be made that the content of those records were already in the public domain. And then she adds in 3 that most of the variables are on a spectrum, which is absolutely right, not simply a question of removing a particular cohort from the represented class. And then she illustrates the point she's making by referring to some slices that you could remove, for example, those who had died or those whose data was over a certain age. But she said, by contrast, amending the class to exclude those whose medical information was already in the public domain to a particular degree, and those whose medical records did not contain a certain level of health-related content, be much more difficult. And then she says, and this is in our submission a perfectly sensible practical reason, attempting to amend the class in this way to introduce further nuanced criteria to the claimant class would also give rise to profound practical problems. It's very difficult to see how this could be achieved in circumstances where the identity of most of the current class members and the details of their transferred records are unknown. And then she makes the point about the representative claimant having a second go, and I've made my point about it really being a third go. My lady, those are compelling reasons which support, in our submission, a case management decision which was not plainly wrong. The claimant took a strategic decision to take a stand on his existing pleading. And in our submission, that is not a plainly wrong case management decision. Indeed, it is one within the reasonable range open to the judge. But there's a hard-edged point as well, I've made it already, which is even the latest amendment, page 45, doesn't grapple with public domain. Even now, I don't know what we are, the 5th iteration of the definition doesn't address what the judge set out clear as day in the paragraphs I've shown you in 185, that difficulty, and the claimant can't surmount it. They make some attempt to surmount the level of health-related content by incorporating at page 45 the requirement that the PDI field was filled in. But all that would get them, my lady, would be the identity of the clinician. We saw that when we looked at the sample HL7 record. And would it really get them past the problem they identified if a record said and was seen by the registrar, or and was seen by the triage nurse. That would mean that that field was populated. It's a desperate attempt to come back with some minimum level of medical content, having run the case below on the basis that there was no dispute about the common content, lowest common content of the records transferred. And so in our submission, the judge was right, and her decision is not challengeable on appeal, but in any event, even the latest attempted amendment doesn't solve the problem, and if anything, shows that the judge's appreciation of the issue in particular of public domain was well founded. Maybe just before, or unless there's anything further I can say.
Thank you very much. Yes.
I'm going to deal with the matters in reply in the same order that my friend did, which was following the order of the various grounds of appeal. Can I begin with ground 1 at 1A, the reasonable expectation of privacy? My friend said that medical records are a subcategory of health information. We agree. They are a subcategory of health information to which particular considerations will apply, and will apply in every case. It follows that what is said generally in the case law about health information and about there being a spectrum in relation to health information does not automatically apply to medical records. There is no automatic read across. The fact that information is in a medical record, as was reflected in some of the questions put to my friend by the court in this part of his submissions, the fact that information is in a medical record is in itself a significant point about the information. Not just what is the content of the particular medical record, but we are dealing with a medical record rather than health information that is conveyed in some other way, e.g. because a friend of the patient who knows it has chosen to pass it on. On this case, there is a reasonable expectation of privacy across the whole class because of a combination of three things. Firstly, all of the information transferred constitutes medical records or parts of medical records. That is clear from Mr. Hughes's evidence as to what was transferred. There's nothing in there that does not constitute a medical record or part of a medical record. Secondly, because of the use to which the information was put. And thirdly, because of the absence of consent from or even information to the patients. It's those three things that are taken together that establish a reasonable expectation of privacy across the whole class. Now, it's said against me that our approach fails to honour the principle that a reasonable expectation of privacy has to be assessed by reference to all the circumstances of the individual case. But once one is looking at the lowest common denominator case and whether there is a reasonable expectation of privacy in that case, and we say that there is, one is approaching by reference to all the circumstances of that particular case. The importance of looking at all the circumstances, that point is often made in conjunction with a reference to the Murray factors. You will have seen in our skeleton argument, and I made the point in my submissions earlier today, we address all of the Murray factors and how, in the light of those factors, there is a reasonable expectation of privacy, we say, across the whole class. My friend raises a particular point about the individual who left without seeing a clinician. The point that we make in that regard is that even in that context, an HL7 message would be generated. That would be part of the medical records. Indeed, absent an HL7, there would be nothing in that case to be transferred to Google. That brings into play the expectations in relation to medical records. That brings into play the point that I made as to the disparity of power between the patient and the medical provider. From the patient's point of view, I described the medical records, the HL7, whatever they may be, as a black box. The patient cannot be expected to concern themselves as to what is actually recorded in their medical records, a matter which will be out of their control and, in general, out of their visibility. The patient's expectation, we say, is that the medical record, whatever it might be, won't be shared except for the purposes of direct care. What is there that defeats this general expectation of privacy in relation to medical records? Well, the key point that my friend makes is that what would defeat that expectation would be the information coming into the public domain. Now, I'll come back to that when I address ground 1B, but in general I say that this point about publicity fails to reflect the difference between the significance of a piece of information simply viewed in isolation and the significance of the fact that that piece of information forms part of medical records. I want to say a little bit more about some of the cases. There were some cases that my friend took you to that I hadn't taken you to, or some passages that he took you to which I hadn't taken you to. This was primarily in the context of what he said about my ground 1A. Can I begin with the Bloomberg case, which you have at tab 23 in the authorities bundle, page 792. And there are various passages in Bloomberg that my friend took you to. So he took you to paragraph 52 in Bloomberg, page 826 in the authorities bundle, and the passage from Gatley that was set out there, and the passage which seems to be adopted here by the Supreme Court, there's no suggestion that it's wrong, that there are certain types of information which will normally, but not invariably, be regarded as giving rise to a reasonable expectation of privacy. And those include, the very first example given, the state of a person's physical or mental health or condition. So that normally, but not invariably, gives rise to a reasonable expectation of privacy. If it's incorporated in a medical record, which is not specifically addressed here at para 52, we say that that circumstance will tip over so as to say, well, yes, there is a reasonable expectation of privacy. My friend then took you to paragraph 55, the proposition that there's no reasonable expectation of privacy in trivial or anodyne information. We say, particularly in the light of the GMC and NHS materials that I took you to, that even in the lowest common denominator case, the information with which you are concerned in this case cannot fairly be characterized as being trivial or anodyne. Now, then my friend took you to paragraphs 66 to 67, and the notion of a general rule or legitimate starting point in relation to particular kinds of information, in relation to the kind of information at issue in Bloomberg. The court was saying that there was a general rule or legitimate starting point in relation to information about a person under criminal investigation. Now, they had in effect at para 52 said that there is a general rule or legitimate starting point in relation to physical or mental health or condition. We say in this case it's not simply that, it's contained in a medical record. So there's nothing inconsistent with our approach and the approach that's being taken at paragraph 67. Paragraph 69, the general rule or legitimate starting point does not obviate the need for the claimant to set out and to prove the circumstances establishing that there was objectively a reasonable expectation of privacy. Well, effectively, we do that by taking the judge's lowest common denominator analysis with the various qualifications I've made to it and saying, in that situation, having regard to the Murray factors, which I addressed in my skeleton, there is objectively the relevant reasonable expectation. My friend then took you to 144 and 150. 144 relates to the legitimate starting point and the significance of that. That's really a point that I've already addressed you on. And paragraph 150, I rely in particular, as I drew your attention to when I made my submissions earlier, to the final sentence about confidentiality supporting the reasonableness of an expectation of privacy. Now, my friend then took you to NT1 and the reference to health information in NT1. That case doesn't assist him, and for a start, the health information, not surprisingly, because this is an open judgment and the identity of the claimants is anonymised, so we don't know much about the health information, but at page 544, paragraph 140, we are told that the information about NT1's health, while intrinsically public in nature, is vague and historic and was made public in the course of the proceedings. We don't know how it became public. There's no suggestion that it formed part of a medical record, and the reference at page 145 to the health information doesn't really add anything. It said it's old, it's out of date, it's not in itself of any great weight. It's clearly very much a peripheral aspect of the NT1 case. This is not something in my submission that assists my friend, or indeed assists this court one way or the other. In relation to the ZC case, paragraph 170, this is behind tab 16 at page 606. Now, my friend places some weight in relation to para 170 on the point that the information was information that the claimant had chosen to make public. And my friend says, well, that helps him with his public domain point. The circumstances of that case are very specific and very different from anything that was discussed either in evidence in our case or that fed into the judge's minimum scenario at paragraph 166, the lowest common denominator. This was a case of somebody effectively waiving their privacy by choosing to bring a private prosecution, by choosing to bring legal proceedings. There's also the point about the element of deliberate deception. Now, none of that played any part in the evidence in this case, or in the judge's lowest common denominator scenario. So this is a case about very distinctive and indeed very unusual facts as to how information came into the public domain. It doesn't, in my submission, assist with the analysis in our case. Then, as far as the bounty case is concerned, that's behind tab 21. My friend took you to paragraphs 52 and 53, page 779 in the bundle of authorities. He relies on para 53 in relation to what is said about the triviality of the information in question. There is no discussion there about the significance of the difference between the information viewed in its own right and the information forming part of a medical record. That's not addressed by the judge. And this is a point that he says himself at the start of para 53 is not a point that received any real attention at the trial. And with very great respect, because of course the judge is one who is well familiar with this area of the law, but it's an afterthought. It really doesn't, in my submission, assist this court in reaching its decision. Z and Finland, you have my submissions on that. I don't think I need to take you back to Z versus Finland. I emphasise what it says about the importance of medical records specifically being protected, and the importance of there being confidence in the general sense, not specifically tied to the concept of a breach of confidence, but the importance of patient confidence in the way that their records are held. My friend took you in general to the discussion of the various cases at paragraphs 71 to 76 of the judgment. This is in the core bundle at page 95. So, just briefly going through that part of the judgment, para 71 refers to Z and Finland, which I've dealt with. Para 72 refers to a very familiar passage from the Campbell case about not every statement about a person's health, etc. And I do, of course, say that that passage is directed in general terms to information about health rather than being specifically directed to information forming part of medical records. The judge then goes on to discuss, refers to A versus B. My friend hasn't taken you to that. Don't think that's in our authorities. NT1 and NT2 I've dealt with. ZC I've dealt with. Underwood I've dealt with. Then the passage from Galati at para 76, that's directed to there being a spectrum in relation to compensation rather than in relation to the prior question as to whether there is a reasonable expectation of breach of confidence. So, in effect, what my friend is saying is that this is a multi-factor analysis that is also saying that publicity is always going to defeat that claim. Now, we say that is not the case, and we say in particular that none of the kinds of publicity that were dealt with in argument before the judge or that were dealt with in the judge's decision would defeat any reasonable expectation of privacy. And that takes me on to ground 1B, the significance of information being made public. My friend said at the start of his submissions on ground 1B that the obligations of the healthcare provider are different from the question of reasonable expectations, and it's the latter that's in issue in this case. I make the obvious point that the obligations and expectations on healthcare providers feed into the other, the reasonable expectations of privacy. My friend took you to paragraph 135 of the judgment in this regard. So going to the core bundle behind tab 7, paragraph 135, one finds that at page 111, and my friend says, well, it's not just referring to social media, it's also referring to other cases in which information might be publicised. Final sentence of para 135. Certainly when it comes to the judge's construction of the lowest common denominator case, the specific example that the judge gave was the posting of information on social media. That's at para 166, subpara 5, page 118 in the bundle. But we say it doesn't make any difference whether one's talking about social media or otherwise. Looking at the two examples that my friend took you to in the supplementary bundle, first of all, he took you at page 282 in the supplemental bundle, 282 following, behind tab 18 and also behind tab 19, to the example of a particular patient who was grateful for the effect of the Streams app in that patient's case, and who made public statements to that effect. It is in my submission an absolutely startling proposition that when a patient does what that individual did, that somehow affects the patient's expectations as to how clinicians or a hospital will deal with that patient's medical information. The implication of what's being said appears to be that that patient's medical information, so far as it appears in the material at behind tab 18 and tab 19, anything in the medical records that reflects that information could be shared by the hospital, for instance, for research purposes, without needing the consent of the patient, without even needing to inform the patient, because any reasonable expectation of privacy has been destroyed. That is, in my submission, a very startling proposition. And I make the same point in relation to the material at page 290 behind tab 20. And we see why in that case the information has been made public. One sees that the 6th paragraph down, which is also the 6th sentence down, the sentence beginning, "Now the business owner is backing NHS Blood and Transplant's national campaign to encourage football fans to sign the organ donor register." Again, it is a startling proposition that because somebody has chosen to disclose something about their own medical history in order to encourage others to sign an organ donor register, that somehow affects that person's reasonable expectations, how hospitals or clinicians will handle their medical records. And we say that's simply not right. And we also rely on the passage from Caldecott 2 at paragraph 44 of our skeleton, which we say is directly on point, apposite, and we adopt what's said there. And I note that that was not something that my friend specifically addressed. In relation to direct care, this is ground 1C, the short point is that for the reasons I previously developed, we say that the judge understated the scope of what was outside direct care. In relation to the specific point that my friend makes about clinical safety and effectiveness training, I'd like to take you back to the evidence that was before the court on this, because I don't want it to be said that I've failed to reflect the evidence that was before the court. So the relevant evidence, you have the first statement of Mr. Hughes in the supplementary bundle behind tab 2 at page 12, and he makes the distinction between two kinds of data, synthetic data and real patient data. And he says at paragraph 17 that in the design and development phase, synthetic data was used. He says at paragraph 18a that pre-deployment testing was carried out using synthetic data. And he then goes on to say that there is clinical safety and effectiveness testing, which he deals with at paragraph 19 onwards, and that involved the use of real patient data, about 200 to 300 patients. And that is reflected in the judgment and the approach taken by the judge. Now, it is, in my submission, very difficult to reconcile what is said there with what is said in the ICO's letter, which I took you to previously, at page 92 in this same bundle, behind tab 6. The bottom paragraph on page 92, my investigation has determined that under the terms of the agreement with the Royal Free, DeepMind processed approximately 1.6 million partial patient records for the purpose of clinical safety testing, without those patients being informed of this processing. So there's a stark difference about the scope of this process, and the judge purported to resolve that difference at paragraphs 156 to 158, and we say that that is just not the sort of difference that was suitable to be resolved at the summary judgment stage. In relation to ground 1D, it's a submission that's put in the alternative, and as I hope I made clear earlier, the purpose of that submission, the significance of it, is to seek to exclude from the scope of the lowest common denominator case the person who went away without being seen. In relation to ground 1E as to distress, it's a short point, and I don't have anything to add to what I said previously about that point. In relation to ground 2, it's really common ground between us, I think, that ground 2 stands or falls with ground 1. The only point that I would pick up is in relation to damages, the question that my Lord Justice Dingemans asked me this morning about waiver of tort. in other words, as I understand it, has anybody approached these cases on the footing of a restitutionary claim, what I think Peter Burks would probably have referred to as restitution for wrongs, on the basis of, rather than looking at any loss, including loss of control damages, looking to recoup the financial benefit, the profit that was made by the body processing the data. The short point is, I can't think of a case where that approach has been taken. There was something not entirely dissimilar that was run as an alternative argument in Lloyd and Google, which was seeking to recover what were called user damages, which was if there had been a negotiation between the members of the claimant class and Google for the use of their information, what price might have been agreed, and that was a potential measure of damages. That way of putting the claim in Lloyd and Google didn't succeed. It's different from a waiver of tort approach, and that's not an approach that user damages approach is not an approach that we've adopted in this case. So I wanted to come back to that question because I had given a rather short answer to it. Now, in relation to ground 3, we say that the judge's decision not to give an opportunity to frame to seek to frame an amendment that would meet the judge's concerns, we say that that is a decision which it falls outside the ambit of what was available to the judge as a matter of case management, having regard to what I emphasised this morning was the draconian effect of that decision. The judge assumes that what would be required would be a very substantial recasting of the way that the claimant class is defined. Our suggested amendment is a very is not the sort of wholesale recasting that the judge is assuming would have to be put into effect. We emphasise that by confining class 1 to people where the PV1 field is completed on the HL7 messages, which is effectively that's the heart of the proposed amendment. Well, for a start, it is easy to discern whether any particular individual does or doesn't fall within the class as amended. And secondly, for the reasons that I explained this morning, if the PV1 field is completed, then that does provide a significant minimal level of medical content in the information disclosed. This is, of course, without prejudice to my primary contention, which is that the class as currently defined gives rise to a reasonable expectation of privacy across the whole class. My friend says, well, what we've done here doesn't address the content of the question of those records that were already in the public domain. So in relation to that, we say, we rely on our ground 1B in relation to that. We say that that is not a matter that needs to be addressed separately for all of the reasons that I've given. If, contrary to my submissions on ground 1A, there needs to be an additional focus on the actual medical content of the transferred records, then our proposed amendment would address that. unless I can assist the court any further, I note the time. Those are my submissions.
Thank you very much. Just going to rise for a moment. Thank you. Well, it's often said, thank you very much to the parties and everybody sitting behind them. In this case, we really mean it. We've been treated, if I may say so, to some excellent arguments on both sides. We understand the amount of work that's gone into this, preparing this case by everybody involved, and we're very grateful to all of you. We will reserve judgment in this case. We will hand it, you will be provided with a draft to correct errors of omission in terms of grammar and punctuation, but not to re-argue the case, obviously. If we require any further information, you will be asked for it, and the judgment will be handed down as soon as it is possible for us to do that. And obviously the parties will be informed of the date of hand down. If we require any further information, as I've said, then we will ask you for it. I don't think there's anything else we need to cover now. We're very grateful to all of you and for keeping to the time so impeccably. We'll rise now, thank you.